I welcome you all to today's second session. The speaker for this session is Ms. Sudeshna Banerjee from K&S Partners. She is LLB from Calcutta University. Her practice focus is on copyrights and trademarks. Ma'am advises clients on all aspects of trademarks, filing and prosecution, including availability searches. She also handles opposition and cancellation proceedings. In addition, she advises clients on issues related to copyright protection. She regularly appears before the Trademark Office and the Intellectual Property Appellate Board in connection with prosecution and enforcement matters. Today, she is going to speak on geographical indications, importance, identification, filing procedure, leveraging intellectual property for industrial growth, and success stories. So I welcome you, ma'am. Sudeshna, ma'am.
Yeah, hello, can you hear me?
Yes, ma'am, you are audible. You can start your presentation. Yes, ma'am, you are audible.
Yes, okay. Thank you so much.
Start your presentation.
Yeah, 1 minute. Yeah, so I can share the screen, right?
Yes, ma'am.
Okay. Just let me know if you can see.
Yes, ma'am, your screen is visible.
Okay. Thank you, everyone. My name is Sudeshna, and I'm going to, do a presentation on geographical indication and also on how we best leverage IP, for business purpose. Now, the contents of today's presentation is mostly what is GI. So GI stands for geographical indication, and also a bit of, conceptual clarity between what do we mean by a trademark and what do we mean by a geographical indication, some laws on GIs, some case laws, few case laws, post and, pre and post registration steps, and also some concluding thoughts. Now, when we talk of GI, what do we mean by GI? So I will be referring geographical indications here as GI because that is how it is, it is known as. So what do we mean? You can see, certain pictures that I have posted here. And, so you will see, there are a few things which are marked here. So here, if you know, this is basically the logo for Darjeeling tea. This is for Mysore sandal soap. This is for a specific shawl. This is for, Kutch embroidery that we see. And this is for a specific cheese. Now, when we talk of a geographical indication, like how the name sounds, it is basically, it is, it identifies that a particular product or a goods is originating or it is manufactured from a particular region. And why? Because that region has certain specific qualities or characteristics which is very specific to that good, and it attributes to the to the growth or to the manufacture of that particular good from that particular region. So here you can see Darjeeling tea. There are some specific attributes to the region of Darjeeling which makes the tea so a geographical indication. Similarly with Mysore sandal soap. So this is exactly what we mean by a geographical indication, that a product is manufactured or it is grown in that particular region because of certain specific characteristics which is attributable to that specific region, and that is why it makes the product a GI. Now, conceptual clarity. Now you see when you're going to, for shopping, or, you go to a supermarket or any shop, you will see these are the packets or the labeling that we see. Now here we need to understand what is a trademark and what is a geographical indication, GI. Now a product name is a trademark. It indicates the source of that product. So, or source of the person with whom we associate the product. For example, here, in this case, Lipton is the trademark. So it is a brand name. Here, Teachers is the brand name, but Scotch whiskey is the GI, which indicates that this product is manufactured or made in a particular region. Similarly here, Darjeeling tea. So this is a geographical indication which shows that the tea has been grown in Darjeeling, and there are specific attributes, why it makes the tea, why the tea is grown in Darjeeling and why it is called a Darjeeling tea. Similarly, Parmesan cheese. Here, Kraft is the name of the brand, but this Parmesan cheese indicates that it is a GI. Similarly, for here, milk chocolates, the name of the thing, Hershey Smooth. This Lindt is the brand name. So this is the difference between a trademark and a geographical indication. Moving forward, now trademark, what is a trademark? Because there are a lot of confusion that happens between a trademark and a GI. Now, what do we mean by a trademark? Trademark is an exclusive, it's a private monopoly right, which is given to an individual or it's given to a company who's applying for it. Whereas a geographical indication, it is a community right. It is a collective right. Geographical indications cannot be applied by an individual. So today I cannot go and apply for a GI. But if I represent a community of workers, of people who are manufacturing a particular product, which is specific to that region, then I can go as a community right and as a collective right, I can go and apply for a GI in that, apply for a GI. Now, trademark, it reflects trade origin, whereas GI, it reflects a geographical origin, like we saw Darjeeling tea. So it reflects that the tea has been manufactured from Darjeeling. And whereas a trademark, it reflects a trade origin. It will just show that, okay, this particular product, for example, the previous one that we saw, for Darjeeling tea, that particular brand name is associated with a company who is basically selling the product. Trademark, it can be created overnight. You decide on a brand name, you have a product, you decide on a brand name, and you create, your trademark. But a GI is recognized over a period of time. There is a lot of history which is attached to a GI, or which is attached to that particular product, for that particular product to be classified as a geographical indication. It cannot happen overnight. For a trademark, goods can be produced globally. That is, you can manufacture in any part of the world and sell it in any other part of the world. For a GI, it is always has to be produced locally. I'll just go back to the previous slides here. So this is a specific to Darjeeling, tea. Teachers, it is specific to Scotch whiskey, which is grown in that particular region. Similarly, with other products also, it is specific to a particular region. For a trademark, the quality can be varying quality. For a GI, the quality is always consistent because that particular product is either manufactured by a community which is there, or it is manufactured or it is grown because there are certain specific conditions which are fulfilled for that product to be grown in that particular region. Trademark, a mass production is possible. But whereas for a GI, it is always a limited production in the sense that it is only produced in that particular, that product is identified by consumers that has to be manufactured or has to be grown from that particular region. So therefore, production is always in a limited capacity. Mechanization can be employed for trademark, whereas for GI, it is mostly non-mechanization because it is specific to that region. There is a group of community who is involved. It is either something which is done by the hand, or it is produced or grown in that region. So I'm not saying that there is no mechanization at all, but mostly, there are certain, there are certain specific attributes which makes a product a geographical indication. Therefore, mechanization is very less. Next one, what is protectable? Now, geographical names are protectable, like Darjeeling tea, Swiss watch, and also non-geographical names like basmati rice or pashmina shawls. They can also be protectable. Now, for example, basmati rice or pashmina shawls, they are very specific to a particular region from where it is grown. Basmati rice, we all know there is a long grained with a lot of flavor, in them. So they need a specific temperature, specific waterfall, specific requirements for the rice to be grown as a basmati rice. And therefore, there's also a lot of history goes behind it when we are filing for a GI application, because we need to trace the origin of it, and over the years, how it is specific to that region, and how that particular product is only exclusive to that region. So there is a lot of research work, a lot of history which goes in, and a lot of goodwill and reputation which is also associated to that particular region for the product to be claimed as a geographical indication. Who are the people who can apply for a GI? Like I said, it is not an individual right. A single person cannot go, because it is something which is going to benefit a community, benefit a particular region, or the people who are manufacturing products under, in that particular region. So it is always an association of persons or producers, or an organization or an authority which is established under the law, provided they represent the interest of the producers or interest of the manufacturers of that region. Now, procedure for registration. Now, for a geographical indication application, what are the requirements that that are required? Now, first is we need a statement of case, though there is a specific form, but there also the statement of case with documents supporting the details of the applicant as to who is the applicant, what is the interest of the applicant, how the applicant is going to help the community to grow, the producers, the interest of the producers, then the uniqueness of the product. How is that particular product unique to that particular region? What are the factors that make the product unique and unique to that particular region? Historical origin. So it's very important to, like I'm saying repeatedly, to trace back the history of the origin of the product to that specific region. Map of the area. Now, the earliest map possible, to trace back from where it started, how it developed over the years, how the product is associated to that particular region, the agroclimatic factors that are present for the product to be related, or the product to be unique of that region. What are the human skills that go in? And over the years, how the product is specifically identified with that particular region, and how it is associated, or the goodwill and the reputation has the product has achieved that reputation vis-a-vis the region where it is grown from. So these are not, single documents. There's a lot of research which goes in. There's a lot of documents which needs to be filed to substantiate that this product is specific to that particular region. Going forward, now this is basically the stages that happen when application is filed. So once we file the application with all the supporting documents, there will be a preliminary examination done by the GI office. Now, if there is no objection which is raised by the office, then it straight away goes to advertisement, and then if it is not opposed, you will get a registration certificate. However, if an objection is placed, so we have to see what are the objections that are raised, whether it's a legal objection, whether it's a legal plus a technical objection. They may, a registry may call for further documents to substantiate. They may not be satisfied with the documents that we file with the application. So they may ask for further documents, further evidence to show that, this product is specific to that particular region. Then after that, we need to file the response. Then, whatever the objections are, file the response. Then it goes for advertisement. And if the opposition is filed, then it goes ahead for registration. Some GI statistics, though it is not a very updated one, but you can see that GIs are registered in different categories. So there is an agricultural category, we see there's a manufacturing category, which is around 8%. There is a food category and the handicraft. So in India, we see the handicraft is the maximum one that we are, where a GI has been filed. Now, what are the remedies that are available for a geographical indication violation? Now, we have a statutory remedy of infringement, GI infringement. We have criminal remedies also, where a GI, you can file any criminal complaint for any GI violations. Then there are common law remedy of passing up, which is very similar to, trademark or a trademark passing off or a trademark infringement, and border enforcement through custom recordations, where actually, once you have a GI, you can inform the courts in India saying that, these may be infringing, materials, infringing products, and they do not comply with the, with the GI, tag, and therefore you can actually stop them from getting imported into the country. Now, these are some of the case laws that have been, dealt here in India. And you can see that, mostly these cases have been filed by Dyer Meakins Breweries versus Scotch Whisky Association for the use of the mark Highland Chief, here with the use of a device of Scottish gentleman. So these Scotch whisky is pretty aggressive when it comes to protecting their GIs. And they have taken action against several of these people who have been using their GIs, and indicating products which are actually not related, to that particular region or to their region. And they have, favorable decisions have been granted by the courts in India. So Indian courts do look into the fact that, it is a geographical indication, and therefore it needs to be protected as a GI and should not be allowed to get diluted by any other entity. Now, sometimes GIs, become very generic words. So here we can see, when something that we IP lawyers may call genericide, it may be, when it started as a geographical indication, but by the just use of the word, it becomes generic, and it may no longer indicate as a particular product from that specific region. So another thing which causes, GI to die, maybe, it is not recognized or not protected in the home country, and it fails, to disuse, or there is a delay in protecting the GI from that particular region. So these are something, sometimes we see that, GIs lose the value as a GI. For example, sherry, which started as a Spanish wine, but slowly it came to be meant as British sherry, and it was indicative of a sweet wine. Similarly with Epsom salt, which started as a specific salt from the UK, but it became a generic word for sulfate of magnesium, of any origin. So these are some of the things you have to be very particular when we are protecting a GI, to make sure it's not just having a GI application, a GI registration, but also it is very important to make sure how you enforce your rights in the GI. Now, what are some of the pre-registration steps, which is an inclusive process? Most important is to form an association. You have to make sure that everybody is included in it. The manufacturers, the people who are growing it, need to make sure that everybody is included or forms part of the association, and whether also everybody is agreeable to the conditions, or the terms and conditions of the association, that how the association is going to promote the products, in what way it is going to protect it, how it is going to make sure that GI is made available to consumers worldwide, how to promote that thing, how to make sure that the sales rises. So these are all some of the things that an association needs to, keep in mind, when they are forming an association, how best to protect the interest of the manufacturers, the producers, the growers, so that, GI is promoted, and, you can also generate revenue, proper revenue from GI, stop it being, infringed from any third party. What are the market risk, potential market risk? What are the infringing products that you are seeing? How can GI, explore online sales? How can you see, whether there is any way of attracting tourists to buy specific GI products, and whether everybody is on the same page. That is only when you can promote the interest of the producers, the growers, the manufacturers, everyone. What happens if some of these steps are not kept in mind, or some of the these are not considered? You can leave out critical stakeholders. Lack of consensus can result in lack of compliance. There, you can see infringing products mushrooming in different places. Consumers will not get the quality that they, expect out of a GI product. You will not be able to make the consumers associate your particular product as emanating, from that particular region. So if there is no funds created, enforcement becomes a problem, marketing becomes a problem, and protection will never be a consistent one. So, because it is a community right, it is very important that everybody is on the same page and everything gets promoted in a smooth manner. Like I said, registration, it is not anything as a magical wand. You may have registration, but if you're not enforcing your rights, if you're not checking the markets, if you're not tracking down infringers, it will be very difficult for you to promote or enforce your rights in the GI that you have. You need to see whether your advertising is done in a proper way, whether you are stopping infringers, from selling infringing and inferior quality products. Have you tapped the foreign markets for, exports? How successful are you in promoting your GI, not just in India, but also globally? So these are some of the things that is very, very crucial when it comes to geographical indication. Now I'm going to move on to leveraging IP. Today's session is just, to give a very, I just gave a very quick introduction to what GI is, and I will also give a very, a simple and quick introduction to why is IP important and why do we need to protect IP from the very beginning. Now I have two case studies with me to start with. Now, IP, like I said, so here you got an idea that geographical indication, it basically refers to products which are specifically grown or manufactured in a particular region for certain conditions which are conducive to that particular region. Similarly, with trademarks, why are brand names so valuable? Because people blindly go to a shop and will see the brand and pick up the product, and they will purchase it. Now, that is the power of brand, and that is the value of brand, and that is how companies gain their reputation or goodwill. Now this is some of the case study of the Tata brand. You can see now Tatas have trademark registrations for nearly all the marks that they have. So they have around 1,652 marks globally in the name of Tata Sons. So protection is another thing you have to keep in mind, is that IP, when we are talking of IP rights, it is mostly territorial in nature. So whether it's a trademark right or a GI right, it is specific to a territory. So you need to apply in all the jurisdictions separately to protect your IP rights. So they have, trademark registrations, not just in India, but also globally all over the world. Now, over the years, Tata brand has been valued as the most, valued brand in India. It is one of the one and only brand which is globally recognized as, as one of the most valued brands, Indian brands, which is globally recognized, and it is 86th in the global ranking. Global ranking. The brand value of Tata recently, it broke the USD 20 billion mark. Now, Tatas have over the years associated, they have not only protected it, but they have enforced their rights, and they have made sure that people resonate with the brand. When we talk of Tata, they talk of, they make sure that, there is this trust factor. People associate it as a trustworthy brand. People associate it as somebody who's, as a brand from where consumers can get the best value for money, where consumers can blindly associate the brand and think that, okay, I know even if I'm spending a few rupees more, I know that whatever I'm getting from the brand is the correct thing. The products are of good quality, they are not of inferior quality, and because it's a Tata brand, I can go ahead and trust the brand. So over the years, they have not only through their products, but even through their advertisements and promotional materials, they have portrayed Tata as a trustworthy brand of not just Indians here. I mean, starting from Tata Salt, if you see Tata Salt to whatever products they have, whether it is a salt, whether we are talking of branded jewelry under their brand Tanishq, or whether we are talking of watches under their brand Titan, or whether we are talking of the software industry, we see Tata everywhere. And mostly the consumer feeling is that it is a brand that consumers can trust, and they also identify it. It's not just only one section of the public who is identifying, but they have spread out in such a manner that they reach to each and every consumers in India, whether it is from the middle class people, or whether it is the the rich consumers that they are looking at. So it is something it is something that they have built over the years. Their branding, the way they have done their branding, the way they do their promotion, everything is associated with the consumers and keeping in mind the value of the brand, value of the brand with the consumers. So, and also consumers link it with the quality and the trust that people have under the with the name Tata. It's a global brand. Like I said, it is not just valued in India, but also globally. And one of the things, interesting fact is, like, Taj is one of the strongest brand, which is valued at 309 USD, $1 million USD. Now, moving on to another brand is Amazon. Now, we know Tatas have been there for a very long period of time. Now, Amazon is something which is relatively new. And the younger generations really, we have seen the brand to actually, grow. We did not know of Amazon even few years back. Amazon came into the market. They made a place for themselves in e-commerce sector. And from the very beginning, I mean, if we do a little bit of research, you'll get to know from the very beginning, the one aim of Amazon was to make sure that people, whenever anybody is coming to their website to purchase anything, it is done in a very smooth manner. They had a lot of first to their credit. So they made, their main thing that consumers, from one consumer, if one consumer gives a good feedback, then from that one consumer, they will get 6 consumers. So how did they actually align the brand to consumer satisfaction? One is that they made something, first time we see that, consumers can actually go and review products from the platform. So that was actually done to make other consumers believe that, okay, instead of Amazon, the company itself giving a review, it actually made people or consumers think that, okay, before I purchase, let me read through the reviews. what a consumer has said about a particular product. So that actually instilled a lot of trust and a lot of faith in this on the platform. So they actually changed it and said that, okay, we will allow consumers to give review of the products that they have purchasing. So that will allow me more consumers to trust, a particular review, or, go through a particular review and then make an informed decision whether they want to purchase it or whether they want to go ahead and see another product. So consumer insight, they kept, their main thing was that the consumer is first, and the consumer loyalty. So they also made sure that, if a consumer wants, to return a particular product, that should also be made a very smooth process. Consumer care. So these are some of the things that the brand invested in, and they actually, and over time, they, you see from few products, they have now anything and everything, which is available on their platform. Likewise, they have also made IP a very, very important part of their brand. And as you can see, there are more than 2,000 trademark registrations globally for their marks. So whatever marks or things that they have adopted over time, these are all protected, and not just in one jurisdiction, in any jurisdictions that they have business. And for a company like Amazon, it is like global registrations they have. So this is some way that you can actually build up on your IP. You can generate revenue from your IP, and that is how you actually also instill the consumer faith and consumer trust in your brand. And so over time, people will trust a particular brand, and they will know that, okay, this brand, when I'm going to purchase anything from this particular, under this particular mark, I know these are the things that I will be getting. So that is why IP and see, these doesn't happen over time. You have to protect your IP from day one. And otherwise, if you don't protect, there is a lot of chance that, if there is a gap in protection, there are other people who will be taking advantage or misusing your mark. And that time it becomes very difficult for you to actually go ahead and, protect your IP. So, make sure that, IP, whatever IP is getting created, you need to protect it from day one, and not just protect and apply for a registration, but also make sure that you enforce your rights, which is very, very important. Now, I will quickly deal with some aspects of, licensing, why licensing becomes important, and how does it help, people with IP. So basically, if you, you may be a owner of an IP, but if you give it out for licensing, you can conduct business in foreign markets as the licensor. You have the right to maintain quality control over your products. As a licensee, there are certain advantages is that you already, instead of doing your own R&D and coming out with your own IP, you already have an established IP, and you can take advantage of that established IP. Not just advantage of the R&D or the product, but also the advantage of an established name and reputation which is associated with that particular IP. And as a licensee, you can also cut down your research and development cost. Similarly, for the licensor does not give away his IP rights. It is only he retains the entire ownership. He also gets, you can also generate revenue through royalties. It helps the licensor to enter markets where he may not be able to enter. It can be a financial constraint or a business decision that happens. But when you're licensing out your IP, you are able to reach those markets and also, generate revenue for yourself. And also, it is a cost-effective way for the licensor. Like I said, you need not concentrate on setting up an establishment in that particular, jurisdiction. You can avoid, or cut down on your manufacturing unit cost or distribution cost or promotional cost, because those things will be taken care by the licensee. And most important for the licensor, you still get to maintain, you have a hold on your quality control. For the licensee, like I said, you get access to protected IP, you get access to the know-how, technology, you can use the brand name. It's a business opportunity for the licensee. The licensee also generates revenue, and also, he gets a marketing edge and need not invest in, other things like a R&D center for himself. So these are some of the advantages when you have a established IP. You can give it out for licensing, and it's advantage both for the licensor and the licensee. However, you need to keep certain things in mind when you are getting into a license agreement, whether you are the licensor or the licensee. It is very important to know with whom you are doing the business or whom you're giving out your license to of your IP. So it's important to know the licensor as well as the licensee, the organizational structure. If you're a licensor, it is important that you know how the licensee works, their financial background, because ultimately you're giving your IP to generate certain revenue, to make sure that even you gain in this particular process. So you need to have an idea about the financial background, the business and the licensing information, or how the licensee, whether the licensee has been in a similar business earlier, the licensees, whether the products and services of interest, they are of interest to the licensee, and also you need to make sure that sometimes whether the licensee has been dealing with similar product of your competitor or not. These are some of the things that you need to keep in mind. And for the licensee, it is also important to make sure that the licensor is actually the owner of the IP. What are the rights that the licensor has? Whether there are other licenses that the licensor is entered into. And for both parties, it is important to know the business plan of the licensee, the promotion and marketing of the products, the sales territories, or any other information that is very crucial to the business. So these are some of the things that you need to keep in mind. Another important thing is IP audit. Now, you may have several trademarks, you may have several IP, you may have several patents, you may have copyright. But if those rights are no longer valid rights, or there are certain issues with them, then having X number of IP may not help you. So that is where you need to conduct an IP audit. So what happens when you do an IP audit? You review your IP portfolio. When I say IP portfolio, it can include anything. It can include patents, it can include trademarks, it can include copyright, designs, GIs, anything that is there, anything that you have built or you have created over the years, that will all fall under your IP portfolio. So you need to review your portfolio from time to time. Make sure that you are the actual owner and you are using and you are holding you have proper IP rights over your IP, and there is proper protection in respect of the products or the services or the invention that you have claimed. So there is the protection is proper. Now, how does IP audit help? It identifies gaps in protection. Now, it may happen that you have a trademark or you have applied for some design, but it is no longer valid, or the trademark is not being used, or the design is, that product is out of, you people have, the company may have said that, okay, we are not going to sell this product anymore, or under that product, there are new goods and services which is also used. So you need to identify those gaps, and if you do an audit, it helps you to identify those gaps, what is present for a trademark, whether it is still valid, whether it covers all your goods and services, whether it is filed in all the territories where the mark has been used, whether it is being enforced properly. So these are some of the things that you can identify when you do an IP audit. It ensures the robustness of your IP portfolio. Like I said, whether if some marks are not in use, if some IP is not in use, it is no longer valid. You need not, you can identify those things, and you need not go ahead and protect it anymore. You can let those things lapse. It also adequately protect the IP owner's interest. Now, you may think that you have a protection, but actually you may not have protection for that particular product, or that in a particular region, in a particular jurisdiction. So these are some of the things that an audit will help you to identify. It can also help you to streamline and exploit your portfolio, and also helps you in efficiency of your assets. So IP is basically an asset. So therefore, it will help you to identify your asset, what is there and what is not there, and for which things you need to reconsider and take a decision. Now, some of the steps is docket your registered and unregistered trademarks, inventory of trademarks, or whatever the IP that you have. So it will help you to identify with the accurate ownership. Now, it can happen that, you may have applied for an IP in the name of an individual when you started off the company, or, in the name of a firm. But over the years, that has now changed. Now it is, you have a proper, a company which is established. Now, whether, the company owns the ownership in that particular IP. So those are some things IP audit will help you to find out. Now, you may have taken the help of some third party to create the IP. Now, whether from that third party the IP has been transferred to your name or not. So these are some of the things you can identify when you do an IP audit. The status of each application, so status of each registration, whether the renewals are in force. So all IPs, they are valid for a specific period of time. So you need to see whether the renewals are in force, not just in India, but also if you have global registrations anywhere. You need to make sure, otherwise if your IP is not renewed, it will lapse. Common law protection, you need to make sure that sometimes you may not apply for the IP, but in that case, you will still have, under the Indian laws, you will still have a common law protection. So you need to track the date of first use, along with, you need to make sure that you keep all documents in place, so that if you are enforcing your rights, you can establish to the courts that you are the prior user, and that use is you can substantiate it through the earliest possible documents and maintain accurate results. Now, if, for example, if you have a work or a stylized mark, you make sure that, both the word mark and the stylized mark is protected. So we can see here one example. Now, stylized mark should be registered to ensure maximum protection. Review of goods and services for your registered marks. Now, in case you have your mark is already registered, you need to make sure that, for example, I'm giving whether this mark has been actually registered for the goods and services for which it has been used, or whether over the years under this mark you're also selling some other things, but that may not have been applied for when you first applied for the application or registration. So you need to make sure whether all the goods and services that you're providing under a particular mark is properly covered by way of registration or not. This will also help you to make sure that when you're going for an infringement action, or you want to go ahead and enforce your rights, either if you have a registration, if you don't have a registration, you can actually, or if somebody else files or gives a legal notice against you, you can always go and check what are the rights you have, what are the rights you don't have, and then in that way also you can cut down on your infringement action or on the infringement cost. So that is what IP audits will help you to identify. Another important thing is the correct usage of marks. We see that most of the time people do not use the correct mark, or sometimes people misuse these markings. They may not have a registration, but they still use the R mark. That is a criminal offense. If you don't have a registration, you cannot use this R mark. Now, another thing you have to keep in mind is like correct use. Now, Dell mouse, for example, you may not have registration over the entire word Dell mouse. It's mouse is just indicative of what the product is. You should not put an R over here. You need to put R over the mark for which you have a registration, like how I've indicated here. So these are some of the things you can identify in an audit. Another important thing is correct recordation. Like I said, when normally we see, companies or a person, say that, okay, they want to go ahead with an IP. They may file it in their own individual name, but in a 1 or 2 years time frame, they may grow. And from an individual, or from a single firm, they become a company. Now, in that case, you have to make sure whether, the IP goes to the company or not, whether there has been correct recordation of IP or change in ownership. So that is very important to make sure, in whose name the ownership is, and whether this ownership has been recorded with the, with the registry. Now, you may have change the name, but it is also important that if you have changed the name, that that recordation is applied for and also recorded in the registry's records. So that is something it's very, very important when it comes to ownership. And like I said, it helps you to analyze gaps. check for any, like I said, whether over period of time, a particular mark may be used for different goods and services, to make sure that whether, that has been applied for and it is protected. Check for any litigation issues, see whether, it is important for you to, stop your infringers. In that case, if you've identified any infringers, you can start off with sending legal notices. Rather than jumping into a suit, you can start off by sending legal notices. Also, if you see, sometimes we see people issue cautionary notice in papers, just to make the consumers aware that who is the actual owner, and not to buy any infringing product from other people whom they see in the market. Also, you need to consider foreign registration. So it is not necessary that you need to apply for foreign registrations in all jurisdictions. You start off with, the jurisdictions where you may have interest, you can apply for, and going ahead, you can, think of the other jurisdictions. Now, it is very important that, also you protect your mark in the jurisdictions where you're starting off your business. So if you protect it in those jurisdictions, it basically gives you a statutory right. And also it will help you from any fraudulent registrations that, you may come up at a later point of time. Third-party use, like I said, having a registration does not, help you. You really need to make sure that, you are enforcing your rights against unauthorized use. You're regularly monitoring the markets, for any infringement actions or any infringing products. This will actually help you in saving cost in the long run. And some of the advantages which I've anyway discussed, it's basically will help you evaluate where does your IP portfolio stand. You can conduct audit before any acquisition or assignment. So tomorrow, if going ahead, if you want to, your business is getting acquired. So if you have a proper IP audit, it will add to the goodwill, to the valuation, to the reputation of your company. And it also analyzes the strength and the weakness of your portfolio. Now, if you don't, for example, if you don't enforce your rights and there are a lot of infringing products, basically a mark becomes diluted over time. And you may not, if there is an acquisition, you may not get the value that you're looking for from your IP. So it is very important to enforce your rights, make sure that, you are protecting your IP, and because this also adds to the commercial advantage and also your future business strategy. So with this, I come to the end of my presentation. I will be happy to take questions now.
Participants are requested to ask questions, if any. Ma'am, I have a question.
Yes, ma'am.
In one of your slide, it is written that, are you tracking infringers? So do we need to be in continuous touch with the third party to track the infringers?
See, continuous touch is, yes, it is very important. Not continuous does not mean on a regular basis that you touch, but, if you come across anybody using, selling an infringing product, you need to stop them then and there. You cannot say that, okay, I have just seen only one product in the market and we will take normally we see that people tend to delay these processes. And what happens, an action which you should take immediately, like I said, you may take an action by just sending out a legal notice. You need not go to the court in the first instance. But if you see that it's an infringing product and that product, is slowly eating into your business, or, that product, you will get to know that today he may sell just few products, but tomorrow, after 1 or 2 years, that few, products can become much more and it can hurt your business. So, that is where it becomes very important that when you get to know that somebody is selling an infringing product, you take an immediate action. Because the law is also, there's very clear, it says that if you don't take an immediate action, and if you let the infringer grow over a period of time, knowing that he's been infringing your product, you may then lose your right to enforce, your IP rights in the court. because courts have also said that, you have slept over for 5 years, 6 years, or 10 years, and then when this person has actually grown, then you're coming and stopping because you see that he's hurting your business. What were you doing from day one?
Yes.
So that is a defense these infringers normally can take. So that's why it is very important that wherever you see, whether it is an online infringement, whether it is, you are seeing on the market, your sales team or your any other team gets to know of any infringing product, take an action, decide internally and take a proactive action. It may happen that by just sending a legal notice, the infringer may say that, okay, I'm sorry, I did not know, I will not infringe, I will change my mark, or I will change whatever the infringement is. So then what happens, you basically resolve that matter within a span of say 2 months or 3 months time frame.
Fine, ma'am. One more question is there, that what procedure industries adopt to go for intellectual property management? Do they have separate cell, or they outsource this task, means they take help of any firm like K&S Partners? You are in K&S Partners.
So normally what we see is that, the big companies, they may have a IP division which may do it. But normally for any of these, like, IP audit or IP due diligence, we see, people who are more versed in IP, who knows exactly what are the things that they need to look into when doing an IP due diligence. Normally we see that people will approach, or an organization may approach an IP firm to do a due diligence. And this is very, true in case of any acquisition. Now, suppose a company A is getting acquired by a company B, and there is a lot of IP which is involved. In that case, company B will engage a IP law firm, to do the due diligence. They will not rely on whatever the company A is telling them. So they will want an external body to do the due diligence and see where the IP stands, how much IP is still valid, what is not valid, or what is the risk involved in each of the IP. So it may be that you may have, a host of trademark registrations, or, patents, or, GIs, or, copyright. But out of those, there may be a lot of litigation involved. Now, if you are involved in a litigation, now an IP audit, or, will help you to understand where does your IP stand. Now, whether you will be able to retain that IP, or whether you are actually, there is an infringement. And if there is an infringement, and the thing is that court says that, okay, no, there is an infringement and you have to stop using, then the value of your anyway IP comes down. Right. So that is what, IP due diligence or a IP audit will help, a third party to understand if there is an acquisition, or if the company is being bought over, what is where the, the IP or the value of that particular IP is.
Fine. So thank you so much, ma'am, for addressing my queries, and for this knowledgeable and informative lecture that comprises all the things like importance of geographical indications for the intellectual properties, and the steps involved in IP audit and its advantages, and many more things you told us. So thank you so much, ma'am, for such an informative lecture. So
thank you so much. Thank you.
Fine, ma'am. So participants are requested not to leave, because I'm just going to share the feedback link. You need to fill that form for attendance and feedback both, and then you are allowed to leave, and we will join back at 2 p.m. for the next session. kindly fill this feedback form and then you are allowed to leave. All of you are requested to join again at 2 p.m. for the next lecture.